Max here with FrizWoods, here today to talk to you about different ways to beat a Maryland theft charge. The first and easiest way is the old-fashioned way, at trial. In Maryland, theft charges can generally be tried before judges and juries. Theft is one of the few offenses that has mostly concurrent jurisdiction between the district court and circuit court. So whether you're charged with misdemeanor theft of under 100 or between 100 and 1,500, or felony theft of 1,500 to 25,000 or more, your case can probably be heard before a judge at the district court or a jury or judge at the circuit court. Some of the other ways to beat a theft case involve having the case dealt with before trial. One of the most common ways revolves around money. Most theft charges have to do with either stolen property or theft of services. Generally, the crime of theft is mostly motivated to be prosecuted by someone's monetary loss. Make that person whole before the trial, and perhaps the state doesn't want to go forward. One of the other common defenses to theft is identity. Many times a person's goods are taken and they think they know who did it, and the police might think they know who did it too. But before the state makes a case and tries to prove it beyond a reasonable doubt, perhaps you can cast some doubt as to the identity of the person who committed the theft or at a trial. Theft is also an intent-based crime. Generally, theft has to do with permanently depriving a person of their goods. So, say for example, you didn't have the intent to permanently deprive the person. You walked away with your girlfriend's phone, but you brought it back. Did you have the intent to permanently deprive her of it? Probably not. Many times, evidence in theft cases are collected by search, seizure, or statement. These type of things are governed by constitutional law. For example, searches and seizures are governed by the Fourth Amendment. Your lawyer could challenge the search of your vehicle or home, whether warranted or not, and you can have a motions hearing on that, and if you were able to, maybe successfully suppress the introduction of the thing that was supposedly taken in the first place, weakening the state's case to a point that they can't proceed. Perhaps you made some sort of incriminating statement, but weren't properly advised of your Miranda rights while you were detained in a custodial interrogation. Your attorney's motion to suppress that statement, if successful, could limit the state's evidence and to the point where they may not have a case left to proceed on. The last way to beat your charges might be by working out some sort of negotiated plea. Say you were charged with theft 1,500 to 25,000. Through your pretrial mitigation efforts of offering the victim full restitution, doing community service, perhaps addressing an alcohol problem that underlied the alleged theft, the state agrees to reduce your charges to misdemeanor theft under 100. At a sentencing, your attorney might successfully advocate on your behalf and convince a judge to offer you a probation before judgment, striking the guilty finding altogether. In a situation like that, having no guilty finding against you, you might have also beat the case. These are just some of the many ways to beat a Maryland theft case. If you would like some information about your case or to have us take a look at it, feel free to reach out to our firm. Thanks.